All right, get ready to dive into the world of California workers' comp. Specifically, we're looking at what happens when things get, well, a little tricky after you get hurt on the job.
Yeah, it's one of those things, you don't really think about workers' comp until you have to, and then suddenly you're dealing with an injury and trying to figure out this whole system. It can be a lot.
It's like you said, you get injured, and on top of that, you're thrown into this maze of paperwork and deadlines and medical terms.
Absolutely, and it's easy to feel lost. But that's where we come in, right? Think of this deep dive as your guide to understanding workers' comp. We're using excerpts from a guide that was actually written for medical office staff.
Oh, interesting.
But don't worry, the information here is super relevant to everyone, whether you're an injured worker, an employer, or just someone who wants to be in the know.
Okay, so let's paint a picture for our listeners. Say you're injured at work, you're seeing your doctor, and everything seems to be going okay. But then there's a disagreement maybe about your diagnosis or the treatment plan, or maybe you're not even sure if you qualify for certain benefits. What happens then?
Well, that's where the role of your treating physician becomes super important. Their reports actually carry a lot of weight in the workers' comp system.
So my doctor is kind of like my advocate in this whole process.
Exactly. They're not just treating your injury, they're also advocating for you within the system. Those reports they write can really impact whether you're eligible for things like temporary disability payments, permanent disability payments, or future medical care.
Okay, so good communication with my doctor is crucial.
Absolutely. You want to make sure your doctor fully understands your job, how your injury is affecting your ability to work, and all the details of the incident. And, just as important is making sure your doctor's office is filing those reports on time. It's a team effort, really.
Got it. Open communication is key. But what happens if I disagree with my doctor's opinion? Or if the insurance company disagrees?
Ah, that's when we enter the world of the Qualified Medical Evaluator, or QME.
QME sounds intimidating.
It can sound that way, I know, but think of it this way. It's like getting a second opinion, but with maybe a little higher stakes. A QME is an independent doctor who provides a completely neutral evaluation.
Okay, so it's sort of a tiebreaker situation.
You could say that. And here's something interesting. You, the injured worker, get to choose what specialty your QME is in.
Wait, I get to choose. So there's a little bit of power for the worker in this process.
Exactly. It gives you some control. Of course, you'll want to talk to your treating physician about which specialty makes the most sense for your injury, but ultimately, you make the call.
Okay, so I have some say in the matter. But how do I actually get a QME? Is there like a directory somewhere?
Well, if you don't have an attorney, you'll need to request what's called a QME panel from the Division of Workers' Compensation, the DWC. They'll then send you a list of 3 doctors in the specialty you chose, and they'll try to find doctors located as close to you as possible. You then contact one of those doctors and schedule your appointment.
So it's a process, but at least you have some choice. What exactly happens at the appointment?
The QME will do a physical exam, review all of your medical records, and then assess your injury. They're looking at how severe the injury is and how it's affecting your ability to work. And it's important to remember that the QME is not your treating physician.
Right.
They're not there to actually provide any treatment. Their job is to be completely unbiased in their assessment of your condition.
So in a way, you're going to this appointment almost like it's a mini trial. You have to be ready to present your case.
That's a great way to think about it. You want to make sure you're prepared to answer the QME's questions thoroughly and accurately. And speaking of being prepared, we need to talk about timing. You actually have to schedule that QME appointment within a specific time frame. It has to be between 25 and 60 days after you receive that list from the DWC.
Wait, so there are deadlines even before you see the QME?
Exactly. You don't want to schedule it too early because the QME might not have all of your records yet, but schedule too late and you risk facing delays or even having to start the whole process over. And here's another thing to keep in mind. The QME's office has to notify you, the insurance company, and your employer within 5 working days of scheduling the appointment. Everyone needs to stay in the loop.
No secrets allowed.
Yeah.
But why so many deadlines? Seems like that just adds more stress to an already stressful situation.
It's really all about ensuring that things move forward fairly and efficiently. This is your health, your income, your future we're talking about. There's a lot at stake. But with deadlines, unfortunately, comes paperwork, and that's where things can start to feel really overwhelming.
I was just thinking that. What kind of paperwork are we talking about here?
Oh, there are forms and records and deadlines galore. We're talking about things like the employee's permanent disability questionnaire, the request for summary rating determination, the QME findings summary form.
Okay, my head's spinning already. I'm picturing myself just drowning in a sea of paperwork. Help!
Don't panic. It's not as bad as it might sound. The QME's office and the DWC can help guide you through the process. Just remember, having a basic understanding of what's required can be really empowering. Knowing what to expect and what questions to ask can make a huge difference in how you feel about the whole thing.
Okay, deep breaths, deep breaths. So let's say I make it to my QME appointment. I've got my ID, I've filled out all the forms, but then I get this nagging feeling that I'm forgetting something. What could it be?
2 words. Key documents.
Hmm.
Make absolutely sure you have the employee's permanent disability questionnaire and the request for summary rating determination. These forms are super important. They're actually essential for the Disability Evaluations Unit to determine your disability rating. Without them, the process can come to a screeching halt.
Oh, so these forms are like my golden ticket to getting my benefits.
Think of them as the missing pieces of the puzzle. They provide information about your disability, like how severe it is and how it's affecting your ability to work. And don't forget, the QME will be filling out their own form as well, called the Findings Summary Form, which is basically like a summary of their entire evaluation. It hits the highlights of the whole report.
Okay, so lots of forms, lots of deadlines, but these documents are really my lifeline in navigating workers' comp.
That's a great way to put it. And remember, even though it can feel really overwhelming at times, you're not alone in this. Your treating physician, the QME's office, and even the DWC are there to help you and make sure your rights are protected.
Okay, that makes me feel a little better. So what happens after the QME appointment? Does the QME just send the report to the DWC and that's it?
Not quite. After the evaluation, the QME has to prepare a really detailed report, and then they have to serve it. That means sending it to all the important people involved in the case, along with a proof of service which shows that it was actually sent. This part can get a little tricky because there are specific rules about who gets this report and when.
Okay, now I'm really intrigued. Who gets the report and what are the deadlines? This whole serving thing seems like it could cause a lot of problems if it isn't done correctly.
You're right to be concerned about those details. It's really important to understand who's getting what and when, so we're going to dive into that right after this. You are definitely right to be concerned about the details of, serving the report. There are a lot of moving parts.
Okay, so break it down for me, like, who gets this report?
Well, first of all, the report goes to you, the injured worker.
Okay, that makes sense.
And it also goes to the claims administrator, the person at the insurance company who's handling your case. And then if you have an attorney, they'll get a copy too. And
Yeah.
sometimes it might also go to the DEU, the Disability Evaluations Unit.
Right, right. But you said something about deadlines for sending the report, right?
Yeah, the deadlines are super important. If your injury happened after January 1st, 1994, the QME has 30 days to serve the report after your evaluation.
30 days. Okay. What if my injury happened before 1994?
Then they actually have a little more time, 45 days.
Interesting. Okay, but let's be real. Sometimes things happen, right? Life gets in the way and things get delayed. Are there ever any exceptions to these deadlines?
There can be, yeah. But there has to be a good reason. You can't just ask for an extension because, you feel like it.
Right, of course.
Yeah.
So what are some valid reasons for needing more time?
Well, if some test results are missing or if a consultant's report is late
Right.
or, if something unexpected happens, like a family emergency or a natural disaster, things like that, those are usually considered valid reasons for getting an extension.
Okay, so those all sound reasonable. But I'm assuming there's a process for requesting an extension, right?
Oh, yeah, definitely. There's a specific form, the QME timeframe extension request.
Of course, there's a form. But I'm guessing there are consequences if you miss those deadlines.
Oh, yeah, for sure. I mean, you could end up with a denied extension, or your report could be considered inadmissible.
Oh, wow.
And in some cases, you might even have to redo the whole QME process all over again.
Yikes.
Mm.
That's definitely not something you want to risk. It sounds like the QME has a lot of pressure on them to make sure everything is done on time.
Yeah, they do have a lot of responsibility, but, the deadlines are there for a reason. It's about making sure the process is fair and efficient for everyone.
Okay, that makes sense. So we've talked about serving the report and the deadlines and even about getting extensions. Now I'm curious, where does the QME report actually go?
Well, it depends on whether or not you have an attorney.
Oh, okay, so two different paths the report can take.
Right. If you don't have an attorney, the QME sends the whole the whole package to the local DEU office.
The whole package. What exactly does that include?
Everything. The QME report itself,
Right.
the findings summary form, and the DEU forms we talked about before, the ones that are needed for your disability rating.
Right.
Oh, and the proof of service, too, of course.
So it's basically like a big bundle of information that all goes straight to the DEU.
Exactly. And the QME is the one responsible for making sure all of that is, all in order and gets where it needs to go.
All right, so that's if you don't have an attorney. If you do have an attorney, what happens to the report then?
It's a little different in that case. The QME sends copies of the report to both your attorney, the one representing you, the applicant, and to the defense attorney, who represents the insurance company or the employer.
So it goes to the attorneys, and then they kind of take over from there.
Right. The attorneys get involved, and they'll use that QME report as, evidence to make their arguments.
Okay, so they'll be arguing it out, potentially, in front of the WCAB, if it gets to that point.
Exactly. But the DEU still needs a copy of the report too, right?
Right.
But instead of the QME sending it directly, they'll get it from the claims administrator.
So it takes a slightly different route if you have an attorney.
Yeah.
But either way, that QME report is super important for determining what benefits you'll receive.
Definitely. And it can seem like a confusing process.
For sure.
But, even just having a basic understanding of how it all works can give you a sense of, control over the situation.
Absolutely.
It helps you understand what's happening, ask the right questions, and advocate for yourself.
I'm feeling a little more confident already. Okay, so we've covered serving the report, all those deadlines. What happens if you need an extension? Now, I have to ask, who pays for all of this? Who pays for the QME, the report, all that paperwork?
Well, for that, we need to talk about billing and fee schedules, which is a whole other layer of the workers' comp world.
All right, let's talk about the financial side of all of this. Who pays for all these evaluations and reports?
Well, the good news is that there are, standard costs for those things in the workers' comp world. It's all laid out in something called fee schedules.
Fee schedules. So it's like a menu of prices for different medical services.
Exactly. There's the official medical fee schedule for, your regular medical treatment.
Okay.
And then there's a separate one, the medical legal fee schedule for things like the QME evaluations, which are related to, legal disputes.
So that helps to keep things fair and transparent.
It does. But, there can be times when there's a disagreement about a charge. What if you think a bill is just way too high?
That's a good question. What happens then?
Well, that's where something called independent bill review comes in, IBR for short. It's basically like having a referee for those billing disputes.
I like the referee analogy. So how does IBR work exactly?
Yeah. Let's say you get a medical bill, and you look at it and you're thinking, wait a minute, this doesn't seem right. You don't just have to accept it, you can actually challenge it through IBR.
So there's a way to fight back against, unfair medical bills.
There is, but it's important to know that IBR is only for bills for services that happened on or after January 1st, 2013.
Okay, so it's a relatively recent thing.
It is, and the process is usually started by the medical provider, not by you, the injured worker.
Oh, so my doctor would be the one to initiate it.
Right, but they can't just go straight to IDR. First, they have to try to resolve it directly with the claims administrator by requesting what's called a second review.
So it's like a second opinion on the bill itself.
Yeah, exactly. If the provider still isn't satisfied after that second review, then they can file for IBR, but they have to do that within 30 days of getting the results of the second review.
More deadlines. Okay, so let's say the provider wants to file for IBR. How do they actually do that?
There are two ways to do it. They can do it electronically or on paper. The electronic way is through a system called the Maximus Federal IBR Tracking System. They can register there and submit everything online.
Sounds convenient. And what about the paper option?
If they go that route, they'll need to fill out a specific application form and include a few things, like they'll need to send a check for the IBR fee.
There's a fee.
Yeah, it's currently $250, and they'll need to include any supporting documentation they have for their case.
$250? That's not cheap.
I know, but the good news is if the IBR decision is in the provider's favor, meaning they were underpaid, then they can get that fee reimbursed.
Okay, so it's like an investment.
Right, exactly. Okay, so once they submit the application, the next step is for the administrative director, the AD, to review it.
Huh?
The AD is checking to make sure the case actually qualifies for IBR. If it does, then they'll assign it to an independent bill review organization, an IBRO.
An IBRO, that sounds pretty official.
It is. They are an independent organization that specializes in reviewing billing disputes. and they'll assign an independent bill reviewer to the case. That reviewer will look at all the documents and the fee schedules, and then they'll make a decision about whether the bill was correct or not.
So this is where that neutral third party steps in and says, here's what's fair.
Precisely. And the great thing about this is that the IBRO's decision is actually binding. That means that both sides have to follow what they decide.
Oh, so that usually brings the dispute to a close.
It does, although either side can appeal the IBR decision to the WCAB if they want to.
So there's always that option to keep fighting for what you think is right.
There is. But most of the time, these disputes are resolved through the IBR process without needing to go to a full-blown appeal.
That's good to know. It sounds like IBR can be a real lifesaver for both the provider and the injured worker when there's a dispute over a medical bill.
Yeah, it's a really important part of the system, ensuring fairness for everyone.
Okay, so we've explored the role of the treating physician, the whole QME process, billing and IBR, even touched on the appeals process. That was a lot to cover.
It was a real deep dive into the world of California workers' comp. But hopefully, it's helped to demystify some of the processes and given our listeners some tools to help them navigate the system.
I hope so too. It can be a really confusing and overwhelming system to deal with, but knowledge is power. The more you understand about workers' comp, the better you'll be able to advocate for yourself.
And as we always say, preventing workplace injuries in the first place is the best way to avoid having to deal with workers' comp altogether. So, stay safe out there, everyone.
Absolutely. Well, on that note, we're going to wrap up this episode of The Deep Dive. Thanks for joining us on this journey through the sometimes confusing world of workers' comp. Until next time, stay safe and stay informed.